I hope that as time goes by, more Caribbean citizens would understand that they have a right of access to the Caribbean Court of Justice to give effect to the rights that they have under the regional treaty framework under which we all live.
Justice is the quiet architecture of a nation. We rarely see it, yet almost everything we value rests upon it. Our freedoms, our contracts, our very confidence that a dispute will be settled by the law and not by power. The ancient Greeks concluded that it was better for the individual to give up some of his rights to the state, the Leviathan, in exchange for its protection. And at the very core of these protections is the court. The custodians of our legal institutions are seldom celebrated. Their work is patient, unglamorous, and oftentimes thankless. The reform of a court, the education of a judge, the drafting of rules that quietly makes justice faster and fairer for people that they will never meet. Martin Luther King Jr. captured these stakes when he said, "Injustice anywhere is a threat to justice everywhere." It is a reminder that the rule of law is not a luxury for large nations, but the very foundation of small ones like ours. Our next guest has devoted a lifetime to that foundation, raising from the smallest independent state in our hemisphere to the highest courts of the Caribbean and to an international tribunal, a distinguished jurist and a reformer wherever he sat. I am pleased to welcome Sir Dennis Byron to the 1461 podcast. Welcome to the 1461 podcast.
The 1461 podcast is brought to you by Bryson Company Limited in partnership with IBS, Harbour Club, Tropical Solar, and 1461 Enterprise, distributors of the world's best coffee.
Today we are very pleased, in fact honored, to have one of the most distinguished jurists the Caribbean has produced. Someone who has sat at every level, from the municipal court all the way to a United Nations tribunal. We're pleased to welcome Sir Dennis Byron to the 1461 podcast. Welcome, Sir Dennis.
Thank you very much for having me here.
It's such an honor to have you. You are one of those people who I have met on occasion before, but I've read about you, your work, your contribution to the law in these islands. So it's really important for us to get to know a little more about you, your journey, how you started, and what brought you to the heights that you were able to climb. Certainly, your work and effort is well documented, but it's important for historical purposes to also have a conversation with you to ensure that those who have not heard about Sir Dennis have an opportunity to get to know him a little more intimately. So we would like to start with your backstory in St. Kitts. You grew up in St. Kitts, but I'm not sure we know a lot about your early years, what you did, whether you played sport, whether you liked music. What was the earlier part of your life like?
Well, I did play a bit of sport. Cricket was the main thing I played. And I grew up in a home that was a very musical family.
Oh, wow.
Two of my aunts on my mother's side had degrees in music from the Royal Schools of Music in England. And on my father's side, They were also very musical. So the answer to both of your questions is that I did have a background in sport to some extent, and in music to a large extent.
So let's go into the sport. Did you play competitively, or you were not inclined at that point?
Yes, I did make the school team, so I played cricket for the school. And after I left school, I joined the club, the Progressive Club.
Very good. And music, was it an instrument that caught your attention, or?
Well, I learned music generally, the theory of music. I started learning on the piano, but the instrument I began playing more often was the guitar.
The guitar. Well, I started with the piano. My parents were very keen to have me play the piano. It wasn't, I liked it. It didn't like me as much as I liked it. So I see that you were one of the first, I would think, from St. Kitts who traveled to the United Kingdom to read law. And I understand that you read for your LLB at the Fitzwilliam College, Cambridge, and you were also called to the bar in England. And that was way back in the 1960s, huh?
Yes.
What was it like for a West Indian with ambition, a Black West Indian, I think that's important to note, in the 60s in the UK? What was that period for you like?
Well, I forgive me if I start by correcting you a bit. You see, at that time, there was no legal education facilities in the Caribbean. So every person who studied law previously had to go to England and had to be called to the bar in England. Because at that time, the only qualification to practice law in St. Kitts and Nevis, as I think in most of our Caribbean, was being admitted to practice law in England. So everyone before me had made that journey in one way or another. In fact, I had an uncle who was a lawyer.
Okay.
And he had been to England and studied there before he coming home. Going to a university like Cambridge University provides a bit of an insulation from a lot of the problems that Black people encountered in England. At the university, we there was a non-British community there, and we were treated on equal terms with everybody, and I had a very full and good life as a university student, and in the facility living around England under that umbrella as well.
I understood that one of your formative or most memorable experiences took you from Cambridge with some friends, and you drove almost 5,000 kilometers to Jerusalem? What was that about?
Well, I in those early days, I was a bit religious, and with a group of friends, 4 of us, decided to take a trip to try and retrace the footsteps of Jesus Christ.
Okay.
So we didn't have that much money, so we got a long wheelbase Land Rover, and got some tents and sleeping bags, and drove through Europe to the Middle East, sleeping on the way at camping sites all the way through until we reached to Syria and Jordan, where they were. That was not part of the scenes there. And so it was a very interesting trip. When we got into Jordan and Israel, we visited many of the sites that were mentioned in the Bible, and got to see for first hand, put to life things that we had read about in a very meaningful and interesting manner.
And that journey, which I'm sure you have fond recollections of, I would think that it had maybe left an impression upon you about the people of that region, how you were received as a non-Middle Easterner, a Gentile. Did you have a good experience? How were you received in Jerusalem?
Well, we're talking about, this happened in 1963. It was my first, it was the first long vacation, the first summer vacation at university. So there were four of us. We are late teenagers, 19.
West Indians?
No, they are two were English. One was from, at that time, Southern Rhodesia, no, Zimbabwe, and myself from the Caribbean. And so we traveled as a group. And, well, we were very hospitably received, in fact. When we traveling through Europe, there were organized camping sites. And we had chosen which ones we were going to in advance because we had joined the Automobile Association and we got a lot of information about the travel route that we were going to take. But when we got into Damascus, for example, there were no organized camping sites. So we went to the police station there to inquire about camping facilities. And the police got on the phone and came back and told us that the schools were on vacation and he had arranged with the school principal for us to use a school as our base when we were in Damascus. And when we went into Jerusalem, at that time, part of Jerusalem was still in Jordan. And and again, we went to the police. And they arranged for us to sleep on the Mount of Olives.
Oh, wow.
So we set our camp on the Mount of Olives. And we were there for some time.
So many of the places that you read about in the Bible, you got a chance to not only visit, but you slept.
Yeah.
Now, after your time in the UK, specifically Cambridge, you returned to St. Kitts, and
Yes.
I believe you started your legal practice. What was it in the early days for you as a young, budding lawyer, trained in one of the finest institutions in the UK? How was it when you started?
Well, I was interested mostly in advocacy, in being a lawyer who went to court. And in those days, the judiciary was not as well staffed as it is today. So, for example, there was one judge who was resident in St. Kitts, but he also served Montserrat, Nevis, Anguilla, and the British Virgin Islands. So I developed very early a regional practice as I was interested in appearing before the court. So I began practicing throughout that region. We had other courts as well. There was the magistrates' courts where I practiced in as well. And then there was the appellate courts. So my practice grew quite quickly, and I developed quite a good practice, practicing in all branches of the law and before all of the courts in the region.
I see you, by 1982, you were appointed a High Court judge in the Eastern Caribbean, and you, at that point, were able to demonstrate on the bench your capacity. I assume you were pretty young when you were appointed, when you ascended the bench.
Well, I was born in 1943, and I was appointed in 1982.
That's pretty young for a judge. How was that your initial years on the court as a High Court judge?
Well, the thing that I should tell you that I had not applied to become a judge. The idea of becoming a judge had
your mind?
Had never occurred to me. But I was invited to the bench by Sir Neville Peterkin, who was then the Chief Justice. And I was assigned to Antigua. But although I was assigned to Antigua, the court used me as a sort of a fireman, going to several jurisdictions where there were issues at net. So I served during my early years as a judge in Montserrat, I also was sent to Dominica when there was a sensational murder trial, which they didn't think the resident judge should hear. I also came to Saint Lucia when the resident judge here died suddenly. And I was asked to come to tidy up his judicial affairs. And so in those early years, not only did I practice, I got a chance to become a sort of a regional judge pretty early on.
Were these called at the time the assizes, moving from one jurisdiction to another?
Well, the assizes were one aspect of the work. That was the term used to refer to the court when it was doing criminal cases. So in those days, there would be 3 criminal assizes per year. And then there would be a collection of cases which would be heard during that period. But at those days, we were more a bit of all-rounders because we sat both on, we did all the work that was there to be done.
Civil, criminal.
Everything. And so we did cover quite a lot of cases. We had a pretty large caseload.
Now, in preparing for our discussion, I happened upon a piece of information which I have not been able to verify. So maybe you could tell me and our audience whether that is correct. Did you also participate as a judge in Grenada post-revolution?
Yes.
That was after the murder of Bishop.
Yes.
What was your role then?
Well, as you know, as you might have discovered, when the revolution occurred, Grenada withdrew from the Eastern Caribbean, from the OECS, Eastern Caribbean Supreme Court, and established its own court, the Supreme Court of Grenada. And I think that the then Chief Justice, after some time, decided that he wanted to not continue because of his closeness to everything. So the Grenada government asked the Eastern Caribbean to send someone to act as Chief Justice and to do the trial. And I was selected. And the Chief Justice at the time was Lascelles Robotham. And he, when he spoke to me about it, he asked me to clear my calendar for 6 weeks to go to Grenada to do a trial. I had not had much advanced knowledge of what was in store for me. But I went, and I ended up spending almost a full year there.
So he meant it when he said clear the calendar.
But he said for 6 weeks.
What was that period, which is, I guess, a historical period post-revolution, reestablishing the relationship with the Eastern Caribbean Supreme Court? What was that period like for you? And are there any significant cases of note that you were also assigned to? Well,
the period that I went to Grenada
83
was in 1986.
86.
The revolution ended in 1983, and that was when the Morris Bishop was killed. And the trial took place in 1986. So I went to Grenada in January of that year. And I returned to Antigua in December. I spent almost a full year there. During that time, that was the only important matter I did, although I did do some civil work as well. But that was the only significant matter that I addressed. I absorbed my full time.
Did you, the code, I think it was his associates, did you work on those cases as well?
Well, that case, all this was called the Morris Bishop murder trial. There were 11 people who were killed at the same time. So it was really involved in the killing of all of those 11 persons. And I think number of accused persons were 17 accused persons who were accused of trial in that matter. So it is a pretty big case.
Were they tried separately or?
Well, they were all tried together. There was one indictment, and they were tried together. But during the trial, they adopted a strategy of trying to drown out the proceedings by chanting.
No.
So in the end, I had to bring them in one by one. And each witness had to give the evidence in relation for each of them one. So the evidence was repeated 17 times.
Interesting. You instituted and spearheaded the Judicial Education Institute, and you also introduced the Code of Ethics for judges. What motivated at that time those reforms?
I had been a judge between 1982 until 1996, when I started acting as Chief Justice. And in those 14 years, our court had not experienced any judicial training or education at all. And in fact, in those days, there was no tradition or no perception that the judges needed further training. If you're already a judge, you were expected to be able to understand and to fulfill the functions of a judge. But I had different types of experiences during that period. And in fact, one of the notable experiences was occurred in around 1995 when President Aristide was reinstated as the president of Haiti by the American government, who also decided that because the country had been in a dictatorship for such a long time, that there should be a judicial training to equip them with the skills to function in a democratic environment. And so the National Center for State Courts in America invited me to be a member of a three judicial faculty that would run the training program. Incidentally, I said incidentally because it presaged other relationships. Justice Jacob Witt, who eventually became a judge of the Caribbean Court of Justice, he was also on that three-man judicial panel. And we spent, we had a 5-month period doing judicial training work in Haiti.
Oh, wow.
Now, it was quite ironic because there was I participating in a judicial training program in Haiti when we had never had any judicial training program in our courts.
Maybe it was thought that he needed it more than we did.
Well, but it had an impact on me. And it made me understand quite a bit more about the value and importance of judicial training. So when I started acting as a Chief Justice, I started in July. That was when my predecessor, Sir Vincent Frosak, retired. I took with me one other member of the court, Justice Albert Matthew, who was also interested in education, as having been recruited from the law school, university. And I took him to Halifax to attend an intensive study program for judicial educators run by the Commonwealth Judicial Education Institute. And that turned out to be quite a transformative experience because we learned about how to set up or organize national educational programs by understanding what the needs were, how to employ adult learning techniques, how to train judges, to train other judges, and how to evaluate the impact of the training on the judicial outcomes. And when I came back from that training program, I established the Eastern Caribbean Judicial Education Institute. And we started working right away. In fact, that started another development in my life because, in fact, what got around a bit. And by the following year, I was invited to be on the teaching faculty of the Commonwealth Judicial Education Institute and began doing training programs throughout the Commonwealth. And I eventually became president of that organization.
The Commonwealth?
The British Commonwealth.
Yes.
So it was the Commonwealth Judicial Education Institute.
Wow.
And so the remit of the institute covered the entire British Commonwealth.
So after your education, back to St. Kitts, served in Grenada, served in Antigua, and then you throughout the region, and then you set your eyes to helping to improve the quality of the judges, and you started the Regional Judicial Education Institute. So not only a judge, not only an advocate, but also an educator.
Yeah, well, that became a big part of my life.
Very good.
Because even today, I was the chairman of the institute, and I still participate in its educational programs.
Very good. After the break, we will come back. We'll dive a little deeper into the work of Sir Dennis Byron, and you'll get to know about his exploits working for and contributing to the International Tribunal in Rwanda. See you after the break.
Coming up after the break, more with our guest.
As a building contractor, the success of my projects depends on the quality of materials and the reliability of my suppliers. Bryson Company has consistently provided high-grade roofing and steel products that meet the standards required for both residential and commercial work. The customer service is excellent. Orders are processed efficiently and delivery is always timely. I appreciate their professionalism and commitment to quality, which makes them a trusted partner in my business.
To experience the benefits of a tropical solar water heating system, call 453-1868 in Castries or 454-6344 in Vieux-Fort.
So one of the things which distinguishes your career is the fact that you served in one of the most well-known, most well-renowned, and I dare say well-respected international tribunals, and that would be the International Tribunal, Criminal Tribunal for Rwanda. You were appointed to that tribunal, I believe, in 2004. And you participated in some of the most consequential, let's say, cases, including the military one case, which saw a number of those military officers who were implicated in the genocide receive justice. Tell us a little bit about how you became involved, and of course, being appointed by Kofi Annan, the then Secretary General. What was that experience like?
Well, it started off by being unexpected. I had not applied to become a member of that court. But it happened that there was a Kittian national who was a member of the court who became terminally ill and had to leave. And the rules of the court at that time was that a national could replace him if he was nominated by his government and approved by the United Nations. So all that process occurred without any consultation with me. And I found out about it when I got a letter of appointment sent by Kofi Annan.
Wow.
But I eventually accepted the appointment and embarked upon the tour of duty.
And you were based in Arusha in Tanzania, because I understand that the court had offices in Arusha, in Kigali, and I think there was one in Amsterdam.
It had in The Hague.
Yes, The Hague.
And also it had officials working in New York.
How was that period and your introduction to that tribunal, which did not work on municipal law, it was international law? How did that, of course, your legal education, the work that you had been previously engaged in, moving from that focus engagement with municipal law and now looking at international law, how was that transition for you?
Well, it was very interesting. I mean, I did have an education in international law, and it's very interesting that you see, judging in the Eastern Caribbean provides a lot of I suppose a background that's, when one looks at it, is much bigger than one would anticipate. So, for example, I was already accustomed to working in a regional court, which served several jurisdictions, and it served a court which had mixed jurisdictions of civil law. Saint Lucia, for example, was a civil law and common law jurisdiction. So the major transition of moving from a municipal court to an international court was applying international law, which was basically the best practices of both the civil and the common law. And I had already been experienced to work in a jurisdiction where that was what we were doing. So the learning the new systems, which basically were the rules of procedure, were a hybrid of common law. The learning curve was not surprising or difficult or shocking, but there was a learning curve that you had to go through. And then you had to learn the principles of international criminal and humanitarian law. And one got thrown in to the deep end pretty quickly because the tribunal was a fully functional entity with a lot of different branches to it, because it had it's a judicial branch, which was staffed by I think we had 18 judges, a large complement of senior legal officers supporting it. It also had a prosecutorial division, which was responsible for investigation and managing witnesses. And then, of course, it had its administrative division, which had a lot of other duties. So it was a pretty large entity with a staff of 1,500 from 88 different countries in the world. Again, I suppose, although the Maurice Bishop murder trial was not necessarily preparation, it was still a situation where you had the issue of the senior government officials on trial for the murder of a prime minister. And one of the significant points about the tribunal in Rwanda was that its mandate from the United Nations was to try those who were most responsible for the genocide. And it had two ancillary mandates. One was to facilitate reconciliation between the former combatants and to restore peace in the Great Lakes area. Now, the people who were accused were the heads of government, prime ministers, ministers of government, military commanders, leading businessmen, leading media journalists. So you had the ruling elite of the country, and the concept was to make it clear that even though the court could not undo atrocity, it could affirm that individual responsibility, so that officials could not hide behind state authority, and that people would become individually responsible for the crimes that they committed, and to ensure that the rule of law applied to everybody. No one could claim immunity because of office. So the tribunal issued something, I think it was in the vicinity of 99 indictments of people of that ilk. And that was the basis of the trial.
You also participated in Military One, which is another very important case, which, again, as you quite rightly indicated, those implicated could no longer hide behind their function and were also brought to trial and were convicted.
Yeah, I think that the tribunal developed the law of individual responsibility quite significantly, because many of the persons who were tried didn't personally kill anybody, but they were the ones who planned and ordered through other persons the killings of people. So the concept that was, I think, firmly established was that people who held important office would be individual responsibility for the crimes that they planned, the crimes that they ordered, and the crimes that they oversaw, whether they personally participated in them or not.
And that is now an established part of international law.
Oh, yes. There have been several persons who have been convicted on that principle.
So in your view, your experience in Grenada, your experience throughout the region, whilst you may not have practiced specifically international law, that helped to give you the background, and particularly, as you said, Saint Lucia, which has a mixed legal tradition, civil and civil law as well as common law, helped you to effectively discharge your duties. I understand by 2007, your talents and your engagement brought you to become the president of the International Criminal Tribunal for Rwanda. Tell us about that experience, being appointed in such a distinguished and important tribunal, international tribunal, I assume under the then Secretary General Ban Ki-moon, to take on that very important role. How was that for you?
Well, again, the first point is that the president of the tribunal is not appointed. He is elected by the international judges for a term of 2 years, and he can be re-elected for a term of 2 years. So I was elected first in 2007 and re-elected in 2009. So the being tribunal of an organization of that nature, though, added a dimension to my judicial work, because we then became responsible for the efficient operation of the tribunal as a whole.
Administrative element.
Well, the whole tribunal, because as I'd mentioned before, there were several different operations that were taking place at the same time, which all needed to be properly managed and coordinated. And then you also had to have the issue of the some of the technical issues involved were the fact that the tribunal, not being a state, didn't have the power of arrest. So it had to coordinate with member states, which required a continuing diplomatic function to manage the arrest and transfer of arrested persons to the tribunal. And there were, there was a degree of transparency and accountability, because the tribunal was expected to and did. As president of the tribunal, I had to provide reports to the Security Council twice per year, and the General Assembly once per year. And at the Security Council, one was exposed to the questions if any member states had questions. So there was a tremendous learning experience in complying with the standards of international institutions, both administrative and accountability standards. One of the challenges that we had at my the presidency imposed, though, was that the United Nations had begun to get tired of funding the tribunal and wanted it to be brought to a conclusion. And part of the reason was that the trials were taking a very long time. But as I mentioned, one of the mandates of the statute setting of the tribunal was to facilitate or foster reconciliation. And the theory that reconciliation could be fostered by producing a judicially verified record of the facts, which itself required that the prosecution covered the entire wrongdoing. So, for example, if one charges somebody of genocide, you could convict them for an act of genocide. But if they were involved in several other acts of genocide, the victims or the survivors or the relatives of survivors would feel they had not got justice. So you found that the indictments, they were extremely lengthy, covering allegations over a number of years, and a number of different incidents and venues. So the trials had to. So there was in the situation where I'd been an advocate against delay, against making certain the proceedings. But here we had a situation where there was an institutional requirement that the prosecution covered all of the killings that took place, so that everybody in the community
could
have a sense of justice and get a verifiable record of what actually transpired. So those are one of the tensions that I had as president, which we managed.
So by 2011, you had concluded your tour of duty.
Well, my second tour as president.
As president. And of course, that prepared you for what was to come next. So after the break, we will speak to Justice Sir Dennis Byron about what came next, which was his ascension to the Caribbean Court of Justice.
Coming up after the break, more with our guest.
As a professional plumber installing many different brands of pumps, I'm beyond impressed with the Pedrolo line of products from Bryson Company. With a better performance ratio, energy efficient, less noise and turbulence, the Pedrolo line of products is a game changer for all applications. Whether it is self-priming pumps, booster pumps, submersible pumps, deep well or drainage pumps, Bryson Company caters for all your needs. Don't hesitate to get yours now.
Yo, call it. Yeah. Keep all your bad son.
Keep all your bad.
Girl a skinny thought, give me and a tell me fi pokey. She a tell me say fi grab it throat and choke it.
She a send picture and a send me emoji. Give me good brain and fi give her a trophy.
Hardy than Dada, Louis V shirt and a new band crabber. We a do it first and the whole of them a follow. Girl them a twerk and I say them want hammer.
Girl them a bubble and a wine and catch.
She be a first class, me a driver.
Stick up on a day, you know what man, no stick up on a day. No one miss off, first stick up on a day. Aye, we have a bad bite, we ain't nobody say about the best ride. But we go fuck up in a bent paradise. Your pop so tight and your pop paradise. But come at me on bikes and a guys and a man.
Si on va content, c'est la même. Rien à foutre, vas-y par la main. Son a yo bof, yo ka fait moins la peine. Son ka bon moins la flemme, son ka sous c'est pour la fame. C'est nous qui boss, oui bim, même police peut pas stop. Fait faute, nous qui n'est ça sous contrôle. Even nous, ça qu'a grillé, nous toujours bien habillés. L'on 18 carats à briller, c'est nous qui boss. Oui, bim, même police peut pas stop. Pas fait faute, nous qui n'est ça sous contrôle. Even nous, ça qu'a grillé, nous toujours bien habillés. L'on 18 carats à briller.
C'est dedans, nous trois à l'aise. Nous sommes dehors, ce soir. Tonight we outside.
Welcome back. So, you were working, supporting the work of the ICTR, International Criminal Tribunal for Rwanda, served as president. But of course, your work was not done yet. You set your sights to return to the region, to again continue your contribution. By 2011, you were appointed the president of the CCJ. What did it mean to you, having worked in the International Criminal Tribunal for Rwanda, having served the region in various capacities, to return now to the highest court of the region? What did it mean to you to return?
Well, from the time I was a student of law at Cambridge University, long before the idea of the CCJ was floated, I had already formed the view that as a matter of my human equality with, for example, English people, that we should be the final arbiters of our judicial process. So for my entire legal career, I was looking forward to the repatriation of the final judicial resolution to the Caribbean. And so when the CCJ was being discussed, and when it was being promoted, I was a very active advocate and participant in its promotion. So the idea of being part of it was kind of a fundamental dream and aspiration that I had. So when the position of president was advertised, because as you know, the term of duty of the president is 7 years. And the first president, President de la Bastide, his retirement was to take place in September of 2011. And the position was advertised and I applied. And my application was successful. So I joyfully came to the Caribbean and took up that appointment.
Now, the CCJ has come in from time to time by those who were reluctant to move forward with the domestication or repatriation of our final court of appeal, as well as the court which would be the authoritative interpretive body for the Treaty of Chaguaramas. So matters within the original jurisdiction of the court. there's still a bit of skepticism, but during your tenure, it would be correct to say that there were a number of important landmark decisions which really has had a positive impact on the region, regional integration. One of them would be Chinook-Mairi, which limited the discretion, I guess, of CARICOM governments in matters related to immigration. And that, of course, has helped, I would say, or improved the ability of Caribbean nationals to move from one jurisdiction to another. What does the Chinook-Mairi case mean to you?
Well, permit me to start by saying this. All of the member states have joined the original jurisdiction of the Caribbean Court of Justice. So there's no equivocation about that. So they're all fully members of the court and fully participate in its activity. So they've all agreed that all states are bound by the decisions in each case, whether they are parties to that case or not. Which means that if they wish, they can obtain a right of audience to participate in the argument and discussions in those cases. So the Chinook-Mairi case for me was very important because it taught, I think, us a lesson which doesn't seem to have been fully absorbed and acted upon. Because Chinook-Mairi was a young lady from Jamaica who didn't have any power backing behind her, who decided that she'd seek justice for what she can perceive to be a wrong she suffered by the government of Barbados. So this young lady took on the government of Barbados.
And that was an immigration matter. She was not allowed to enter Barbados for reasons which the court found not to be sufficient.
Correct.
So maybe continue.
And so she got, well, you see, the Caribbean governments have entered into an agreement, the Treaty of Chaguaramas, which provided for
free movement,
hassle-free movement of nationals between the states. And that has been the result of decisions made by the CARICOM heads of government from time to time. And so the right that she was asserting was a right which had been established by treaty between Jamaica and Barbados, among other CARICOM countries, and a right which conferred rights to citizens of these countries. Now, why I say that is important, because here she asserted that the court was able to respond to a claim, and she was successful. And it's very interesting that as a result of her case, the immigration practices of all the CARICOM countries have been modified to give effect to that judgment. But I've read from time to time in the press people complaining of a wrongdoing which falls within the umbrella of treaty rights, which the Caribbean Court of Justice could to which they have access to the Caribbean Court of Justice for. And they have preferred to sort of complain than to use the facilities that the court offers. So I hope that as time goes by, more Caribbean citizens would understand that they have a right of access to the Caribbean Court of Justice to give effect to the rights that they have under the regional treaty framework under which we all live.
But certainly Caribbean governments, because of that case and the ruling, should be well aware of what the limitations are in terms of their own discretion in admitting other nationals from CARICOM. So notwithstanding the fact that, of course, we hear from time to time complaints, it would be member states should be seized now even more clearly of their obligation under the treaty. So hopefully, as you've said, that we will start hearing.
I think that the integration movement is growing to some extent, because in the press one could hear recently that there are even extensions being granted. Additional rights are being conferred by certain countries within the region. So one would expect that the rights of access to CARICOM countries by CARICOM nationals will expand over time.
So in terms of those people who are agnostic, who have concerns about the CCJ, again, some of those concerns are not merited. There is a current matter which is ongoing in Trinidad regarding a couple who were detained under the state of emergency, and they appealed to the domestic court for relief. There seems to be a feeling that by some, at least some of the commentary I've read, that if that matter went before an external court, the Privy Council, that couple would have received some relief. In other words, there is continuing, I guess, tension in some places where people believe that the dispensation of justice would be different based on national and political reasons. That's not justified anymore, is it?
Well, okay, let me start by breaking down what you're, because you see the role of a final appellate court, whether it's the Privy Council or the Criminal Court of Justice, is different to the role of the National Appeal Court. So so I don't think that one could say that there is an idea, a problem, that one should not have a final appellate court of some sort, because I think it's become quite accepted that a properly administered justice system requires to have a trial court, an appeal court, and then a final appeal court. And in Trinidad's case, the final appellate court is the Privy Council. But again, the press that I had access to indicated that the government did make an attempt to go to the Privy Council and were unsuccessful. The Privy Council made a ruling on the matter. So they did have an opportunity to. And in any event, it was the government who appealed to the Privy Council, so that the person who was under arrest did not appeal against the order placing him under house arrest.
But the details for me are not, of course, that consequential. It's really the concern that in some quarters there's a belief that justice could only be fairly dispensed outside, and some believe that if the matter, whether it's the final court of appeal, in this case the CCJ, would be well placed to hear and dispense justice in a fair way. So there's still this tension in our region that, by some at least, that we're not able to, notwithstanding the evidence to the contrary, take care of ourselves. And I'm not sure where and why there is this reluctance. Of course, you indicated rightly that in its original jurisdiction, we're all acceded. However, we only have Barbados, Guyana, Dominica, Saint Lucia, and Belize who have acceded to the court in its appellate jurisdiction. So there's still this reluctance, and maybe you have some thoughts on why.
Yeah. Well, I don't understand why the tensions in Trinidad with this Court of Appeal and the Privy Council should reflect on the Caribbean Court of Justice. I don't understand the connection. Because I am not accustomed to hearing that type of issue coming from Trinidad. I mean, with all of the cases that have been occurred, there's this case where there's a public perception. But that is exactly the reason why you have a final Court of Appeal to address issues of that nature. So I would imagine that if the matters, if there was I don't quite understand your question, you see, because from what I understood, it was the government who appealed, not the citizen.
Well, yeah, well,
and, you see, and then it was the government whose appeal was dismissed by the Privy Council.
Well,
so I don't quite understand exactly.
It's just that there is a tension, at least in the commentary, that some persons believe that relief would have been granted. I guess that there would be a different outcome if the matter was brought outside of the jurisdiction. That there's more confidence in the outcome. To my mind, it shouldn't matter whether it's the CCG or the Privy Council, but there seems to be either political or a societal or a cultural bias in one direction or another. I mean, the facts of the matter, let's set the facts of the case aside, but the commentary which has come out since that case would indicate that there are some quarters of the society who have more confidence and others who have less confidence in our ability to find a resolution within the context of our region. Now, of course, Trinidad has not acceded to the final appeals court. Of course, they have to go to the Privy Council. But the commentary, there is this lingering distrust by some. So I'm just trying to tease out, why are we still, notwithstanding the efforts and the fact that the court has not presented itself in a negative way in any way, the judgments have all been well received. Why is there still a tension, that reluctance by some to accept, and that it's important to repatriate the court? Or, on the other hand, some who think that the outcome, if it's taken outside of the region, would be different.
Okay, well, I'm sorry you linked that discussion to that individual case in Trinidad, because I'm not quite certain how to respond to it in that context. Because as far as I understood it, and again, I might not be well informed, but it was my understanding that it was the government who appealed, not the citizen. So it would seem to me, if that was in fact correct, that the citizen was the one who benefited from the rulings of the court and not the government. But having said that, to address the larger question that you asked as to why some countries have not yet acceded to the Criminal Court of Justice, I think that I don't know how to answer you exactly, because I think that the Caribbean Court of Justice has exhibited its independence. It has exhibited the quality of its judgments, and I have not heard comments or criticisms about any aspect of the work of the court up to now. I don't know if there have been criticisms which have been kept silent. So the intellectual assessment of the court seems to have passed the test of most commentators. Now, the issue as to whether it should become the final appellate court seems to then be caught up into issues which are not linked to the merits of the court, national politics, party politics, and that sort of thing. Because the issue that you refer to in Trinidad seemed to be a clash between political factions in Trinidad. And those sorts of issues seem to play weight into whether a country decides whether to accede to the Criminal Court of Justice or not. Now, the court itself is not in a position to behave like a political party. And so it can get into and manage that type of dispute. It's an issue which has to manage itself. But as far as I can see, I have not heard, I'm not aware of commentators who have said that in its 20 years of existence, the court has not discharged of the functions of a final appellate court in an adequate manner.
No, I do agree. I guess it's not legal commentators, but maybe those people who are political commentators who may have, or social commentators who may have those misgivings. But hopefully, with time, all of the CARICOM member states who have not acceded as yet will see the wisdom and the merits of joining the court in this final appellate jurisdiction. In a recent lecture by former Prime Minister Kenny Anthony, I think it was called "Who Will Guard the Guardians?" He quoted you as saying, "We are continuing to battle for the soul of our constitutional identity." I'm not sure you remember that quote from Kenny Anthony, and if you do, what was he referring to?
He was referring to the judgment, the commentary and discussions on a judgment of the Caribbean Court of Justice on the issue of whether or not the savings clauses in a constitution would prevent the court from making declarations that legislation passed before independence was unconstitutional. And if I were to sort of put it in its full context, from my perspective, one of the important decisions I gave when I was Chief Justice of the Eastern Caribbean Supreme Court, and this goes back to 2001, was when our court, among the pioneering courts that made a declaration that the mandatory death penalty was unconstitutional. My colleague Justice Saunders was a member of the court, and he supported my view. Justice Redded, who was also in the court, did not. Now, that decision did not say that the death penalty was unconstitutional. It said that the mandatory imposition was unconstitutional. And what that meant simply was this. You take, for example, somebody is a professional killer and gets a contract to kill somebody. That's one type of homicide. Another type of homicide might be
domestic.
A wife who has been beaten by her husband for 15 years, and one day she snaps. And no, that's also homicide. The question is, should there be a differentiation between the punishment afforded to those two types of events? And I think that everybody would agree that the courts should make a distinction in the way it punishes people, depending on the enormity
circumstances
of the crime. And that is where the judicial discretion in the sentencing process comes into play. Now, when you have a mandatory death penalty, you take away the protection of the citizen from that legal protection. And it affects the dignity of a human being. So we're saying that if somebody is convicted of a homicide, they ought to have the right to present to the court mitigating circumstances, which would influence the level of punishment that would be imposed. That's the simple point.
So it gave the court more flexibility,
discretion to apply judgment,
and
to assess the
facts
of the case, and to determine the degree of punishment that should be afforded.
Now,
that's where it started. Now, at the Caribbean Court of Justice, the matter came before us, where in Barbados, there was a tension as to whether or not the Constitution of Barbados had a clause in it which prevented the judges from making such a declaration, because the legislation which imposed the death penalty had been enacted before the Constitution. So what that basically meant is that the Constitution was interpreted to have a clause which said that any laws that were passed before the Independence Constitution, the court could not say that it was unconstitutional, regardless of what its terms were. And we had a decision where the Privy Council had made a ruling saying just that. And 9 members of the court sat. All 9 agreed that the provision was inhuman, but 5 said that nothing could be done about it because the law had been passed before independence. At the Caribbean Court of Justice, we rejected that proposition. And I wrote the leading judgment in that matter.
That was Boyd? What was the name of that?
The first case from the Privy Council was the Boyce.
Boyce.
Yeah. The CJJ case was Nervey.
Nervey, yes.
And we rejected that proposition that the court was estopped from declaring a law to be a provision to be unconstitutional just because it was passed before the Constitution came into effect. So here we are sitting in the Caribbean, where we sitting as judges seem to be expected to say that our people should not have the benefit of the constitutional rights in relation to laws which were passed under the colonial era. And we said that. And so the phrase battling for the soul
I see.
had to deal with, do we have the right to say that our people are entitled to the benefit of the rights conferred to us under our Constitution?
So the Constitution that we've established post-independence, we were still limited and shackled by those statutes which were imposed or existed before.
Well, the particular provisions which have been interpreted in that way were provisions which in my opinion had a degree of necessity for transitional purposes. Because if the laws it was quite possible that the legal system might have collapsed immediately after independence if the laws in existence were not saved. So the provision had a transitional consequence. But does that last forever? 50 years, 100 years, 60 years? So our ruling was that and I don't want to go into the technical details of the ruling now, but the bottom line was that if the law was in fact inhuman, the court should have the power to make the declaration. That's the simple point.
Well, I think it would be fair to say that the court has done that case has done a good job to ensure that the current constitutional tradition gives the court the flexibility or the authority to give the legal protections that the Constitution provides to its citizens. So I think I
would say that from my way of thinking, that is an important consideration that as to the value of creating a body of jurisprudence which is appropriate to the circumstances of our society.
So I don't want to be provocative here, but would you suggest, and of course we don't know the counterfactual if there was no CCJ, but are we saying therefore that if the same matter was brought before an external court, say the Privy Council, that the court would have found differently?
Yes, the Privy Council has found differently. That's I'm telling you, they found differently in the case of Boyce. And there's a case recently in Trinidad where they have found differently again.
Because it's defending its own tradition, I guess. It's defending its own tradition because it's a pre-independence.
Yes, what they're saying is that that if the law was, well, not if, they agreed in the decision that the law was inhuman. Mm. But it was not for the court to make the declaration. Mm. That Parliament had to rectify the problem. Mm. So, to my way of thinking, it is a completely different philosophical basis as to the rule of law. Because what they're saying is, and you must bear in mind that in England, there's no written constitution. Mm. And so the British Constitution is based on the concept of the supremacy of Parliament. Now, our constitutions are not based on the supremacy of Parliament because our system is based on the supremacy of the Constitution. So I think there's a difference in the DNA of our reasoning. Mm-hmm. Mm-hmm. Because in the Matthew case, the basic concept was, if I may simplify it, because I'm trying not to be technical, but the basic, simple way of putting it, I think, but I think it's fair, is that it's for Parliament to rectify the problem, not the courts. So and we are saying that
it's the Constitution.
On the Caribbean, we have
a Constitution
said that it's the courts who must rectify wrongdoing by Parliament. So they're saying that the courts can't do it. It must when we are on the completely opposite perception that is a function and role of the court.
Hence his question: Who will guard the guardians? So the British are saying Parliament, and we are saying
the courts.
The courts.
Yeah.
Very good. Well, with this, we have come to an end of this segment, and we'll see you shortly after this short commercial break.
The 1461 podcast is brought to you by Bryson Company Limited in partnership with IBS, Harbour Club, Tropical Solar, and 1461 Enterprise, distributors of the world's best coffee. inquiries, contact us at sales@1461.lc or 717-9306.
The benefits of a tropical solar water heating system, call 453-1868 in Castries or 454-6344 in Beaufort.
So, Dennis, I was looking at the different criteria for appointment of judges or justices to the Eastern Caribbean Supreme Court as well as the CCJ. And it struck me that the qualification criteria for the CCJ some may say, and again that's subjective, may be less stringent than the Supreme Court, particularly with respect to time on the bench or time in legal practice. Why is that the case?
Well, you must recall the criteria for appointment to the Caribbean Court of Justice was developed and embedded in the treaty establishing the court, which was made by the CARICOM community. The criteria for the Eastern Caribbean Supreme Court was made by England. It was made under the West Indies Act. And it was made by an ordering council, the Privy Council in England, created the criteria for appointments to the Eastern Caribbean Court. So the authority establishing the criteria was different. Now, with regard to the criteria for the, just if you're interested.
Absolutely, go ahead.
I just pulled up on my phone Article 4, paragraph 10, states that a person shall not be qualified to be appointed to hold or to act unless a person satisfies the criteria in this, together with the criteria in paragraph 11. And it basically says that the person must be, in an aggregate of not less than 5 years, be a judge of a court of unlimited jurisdiction in civil and criminal matters in the territory of a contracting party, or in some part of the Commonwealth, or in a state exercising civil law jurisprudence common to contracting parties, or a court having jurisdiction in appeals from any such court, and who, in the opinion of the Commission, has distinguished himself or herself in that office.
So it's a more subjective criteria.
Or is or has been engaged in the practice or teaching of law for a period or periods amounting in the aggregate to not less than 15 years in a member state of the Caribbean community, or in a contracting party, or in some part of the Commonwealth, or in a state exercising civil law jurisprudence common to contracting parties, and has distinguished himself or herself in the legal profession. And paragraph 11 says, in making appointments to the office of judge, regard shall be had to the following criteria: high moral character, intellectual and analytical ability, sound judgment, integrity, and understanding of people and society. I would not say this is less stringent than the appointment to the Eastern Caribbean Court.
Different is a different sort of...
Well, there are many differences.
Standard.
In the first place, it clearly states that nationality and jurisprudential background is not limited. So you see, you can be a judge exercising in a contracting party or in the Commonwealth or in a state exercising civil law jurisprudence. You understand?
Yeah.
Now, the CGC has had that. It has had judges from the Commonwealth. It has judges from England, another judge from Nigeria, and it has judges from the contracting parties. And it has had a judge from a civil law jurisdiction in Justice Witt, who came from the Netherlands system. Now, and then the other thing it does, it specifically makes provision for academics. It has been engaged in the practice or teaching of law for a period amounting in the aggregate of not less than 15 years.
Okay.
Now, and has distinguished himself or herself in the legal profession. The second point is that if people think that the order in council created from the Privy Council is not good enough, then they should amend it. The legislative process for regulating the court is different to the legislative process for affecting the rules of the Criminal Court of Justice. These were set up by treaty. The legislative effort for this out there is not done by that type of treaty. It requires a different type of legislative process. I am not in a position at the moment to say exactly what is the legislative framework, because I'm not quite certain what body would have replaced the Privy Council under the West Indies Act.
Okay.
But that is the body that is required to frame new laws.
Well, we are moving forward, and of course, the positive thing is that the CCJ is now a more clear and embodiment of the collective legal and jurisprudential tradition, and hopefully the region can continue to go forward. But speaking about going forward, and as we close, you have many accomplishments. You are one of the most accomplished jurists. You've served both domestically and internationally. Looking backward and then forward, is there anything which worries you about where we're going or how our jurisprudence is evolving? And on the positive side, are there things specifically that you are very happy to see?
I must break it down a little bit, because I'm not exactly sure who our means. Because you could be referring to the Caribbean Court of Justice, you could be referring to the Caribbean as a whole, or you could be referring to the Eastern Caribbean. So let me interpret our to mean the Eastern Caribbean. And since you've broken it down to justice, the most important point for me is how do you develop the judicial process? And so it's important, in my view, to strengthen the educational capacity of the court. It has been ongoing, but I think that is, you see, justice improvement does not happen by accident. There must be investment in the persons who are performing duties. Now, the second point is, I could develop that, but the second point is delay is really a serious enemy to justice. But when you analyze delay, it is not always the fault of lazy judges. A lot of it is embedded in the system. How the rules operate, scheduling systems, institutional support. And all of these are issues which can be fixed. So you have to my way of thinking, the education, then you must have the question of analysis of the operating systems of the courts, which really is all of these are roles of leadership. And then the third angle to that is regionalism. There's a tension in the Eastern Caribbean between regionalism and individual sovereignty. But I think that the concept of regionalism needs to be strengthened, because it is impossible for a group of small island states, none of whom have a population of 200,000 people, to replicate processes 9 times. The cost of it would be ridiculously high. And so the collective, I think the Eastern Caribbean Court is an example in point, that the pooling of resources under one regional establishment is much better than what it would have been if you had separate courts for each state. So the concept of regionalism needs to be expanded and strengthened. And I dare say, even in the way I hope that it will go beyond the Eastern Caribbean, and that we'd have a greater linkages between the judicial operations and the wider CARICOM region. Because I think that the enlargement of the footprint of the court would only strengthen it.
The prospect of expanding the number of countries, at least to the appellate jurisdiction of the court, and perhaps expanding it even beyond that, is something which would augur well for the region. And of course, certainly the administration and costs perhaps would be reduced for the average citizen. And of course, you mentioned the benefit of having a court that Shanique Myrie was able to access. In your opinion, do you believe that the administration of justice has improved? And what purposeful steps can be taken to further ensure that the case backlogs, the time for justice to be, for cases to be heard, for more legal training to be instituted? Do you get the sense that we are moving in that direction now?
Well, because this is an area of specialization for me. I can't answer the question like that casually. So this is not a good forum for me to discuss that. What I do say is that I don't think that we are suffering from a lack of talent. I don't think that we are suffering from a lack of ideas. I think that one of the issues that is handicapping us is lack of belief in ourselves and in the realization of what we have. So I am not pessimistic about the future. The delay, for example, in some countries joining the Caribbean Court of Justice, to me, is an evolution is an evolutionary process. And we're dealing now with 20 years. And in the history of people, 20 years is not that much in a certain sense. So I rather believe that it is inevitable, that sooner or later, that these things will come to pass. And we have to be patient. For me, my biggest reason for wanting us to have our own final court of appeal. I recall that I was invited to speak to some school children about accession to this issue, the reasons. And I told them, I said, look, your parents are telling you that if you behave yourselves properly, according to good principles, you study hard, work hard, you're disciplined, you take care of all the right things, that you could become anything that you want. You could be prime minister.
Except.
You could be cardinal, you could be a pope. You could be the Secretary General of the United Nations.
Except.
But you cannot be the head
of
your
final appellate
court of appeal. Because that privilege is reserved for little English boy. And to my way of thinking,
that's wrong. That
puts our children at an inferior position to English children. So my biggest point is that the concept of human equality requires us not to be subordinate to the English court. That we have to be on an equal footing as equal human beings.
It seems like you've anticipated my last question. I'm a big supporter of the court and the work that the court has done for our own Caribbean society, civilization, identity. But I'm also curious that we are moving towards repatriating the court, having our final court of appeal, and inevitably, over time, more and more CARICOM members will accede to the court. That is clear. But is it not past time that the ultimate reflection of sovereignty in these societies, the ultimate sovereign in the society, at least in Saint Lucia, would be the Governor General, who is the King's representative here? So we have a court of appeal. We have a final court of appeal, which is, we are domesticating it. But many of us are still wedded to a sovereign who is no longer ours in a meaningful sense. Is it your sense as well that unless we take steps towards accept ourselves, our worth, and ensure that that final reference point, if you want to call him or her sovereign or president, that we accept ourselves and our value and our truth, that it would be difficult for that child that you speak of to also accept his self-worth. Is it not time for us to cut that umbilical cord and also follow Barbados and become republics?
Well, I can answer just by saying yes. You see, we use the phrase that we are sovereign, but that's not really true. Because our sovereign is a king of England.
Exactly.
King of England.
Not the king of Saint Lucia or Saint Kitts.
No. You see? So, and then there are many other areas where the circle of independence is incomplete. And as I mentioned before, I think that the greatest handicap that we're suffering is a lack of self-belief. And as you have suggested, that completing the circle of independence may help to overcome that.
Justice Byron, Sir Dennis Byron, it has been an absolute pleasure to have you. To our viewers, it has certainly been a treat. And we look forward to you joining us on the next episode of the 1461 podcast. Thanks for watching.
This has been the 1461 podcast. Thanks for watching. Follow us on Facebook, Instagram, TikTok, and Spotify. The Airborne Academy, audio partners of the 1461 podcast.